this is a giant award. Is the size of the award the thing that tells us it's so different, or is the way that this court case happened what's so different about this?
The size of the reward is remarkable. $1 billion is going to make companies much more reluctant to challenge Apple and its patents. But there are many things that are unusual about the case. Most people have paid very little attention to design patents, to trade dress, to trademark dilution.
Sorry, what's trade dress?
Trade dress is one of the rights that the jury found that Samsung violated. It literally means how you dress your package up to market.
Okay.
It's part of trademark.
I saw that in the complaint, that the box itself was part of the issue here, because Samsung's box, according to Apple, was quite similar to Apple's box for the iPhone or the iPad.
It's the box itself, and can also be the design itself can be part of the trade dress depending on how you shape the claim. There are also trademark dilution claims. In other words, before this, the public had an image in their mind of us, of our mark, of who we were. Afterwards, when they see this image, they think of us and someone else. You have diluted our trademark image in people's minds.
Diluted the brand. They hurt the brand.
Diluted the brand.
So is this case different, though, than the way that patent cases have been fought in the past?
It's different in the sense that the design patents are unusual to come with this large a price tag, or even to see this much attention to be paid. And I suspect that over time we will see courts and commentators talking about whether the design patent grants have gone too far, whether we're granting those rights too easily.
Well, and that's what I tried to get to this piece earlier in the show that talked about, Samsung saying, hey, they took a rectangle with rounded corners and patented that. But in fact, the patent, while the verbal description is not lengthy, there are 42 diagrams in just one of these patents that shows exactly how the drawings were done, that this device should look this certain way. Do designs, I understand design patents have been around for a long time, but do design patents, is a patent the right way to protect design?
This has been a problem for the intellectual property system as a whole for a while. Designs are the lost child between all of the different intellectual property systems. You can reach them a little bit in the patent system, a little bit in the copyright system, a little bit in the trademark system, but it doesn't fit well in each of them. And there are definitely some clashes between the notion that a patent system, which is really made to protect function and innovation, is trying to protect something about how an item looks.
Well, and it's intriguing to me too, because it's first of all, it's a very American idea, or at least the initial idea of form following function and form, and Louis Sullivan in the architecture of 100 years ago, but also the same idea of that now that design can do so much more because of technology, that form and function are more closely related, that design is not just a decoration anymore.
Well, patent system believes that those two can be separated. The design patents are supposed to have nothing to do with function. It is very difficult, as you say, to keep those two separated. We also have to remember that it's very easy to get a patent through the Patent and Trademark Office. It's only when it gets tested in court later that you get a sense of whether each of those claims is valid.
So I guess what you're saying is Apple's patents are stronger than ever because of the wind on Friday.